All right. Good afternoon, everyone. I am Corey Rosella, the Executive Director of the Western Center on Law and Poverty. Welcome to today's training on executive orders with Professor David Super. I want to thank the Legal Aid Association of California for co-hosting this two-part series with Western Center, and of course, our gratitude to Professor Super for sharing his time and expertise with us. This training is the second in a two-part series. Last month, we had an overview of administrative law, and today we will talk about executive orders. I'll put a link to the first session's recording in the chat. And just very quickly, for the purposes of this program, we will use the Q&A function, but will not use the chat. Please direct all of your questions to the Q&A, and we will do our best to answer the questions that we can within the time that we have. And to preempt the three most popular questions, yes, I will send you the slides. Yes, this training is being recorded. And yes, we will send MCLE certificates to those who complete our training survey. Now it's my honor and pleasure to introduce Professor David Super. Professor Super teaches at the Georgetown University Law Center, specializing in administrative law, constitutional law, legislation in the federal budget, and public welfare law. Professor Super has been an incredible thought partner to us at Western Center and the greater legal aid community, especially in protecting public benefits programs. Thank you so much for joining us today, Professor Super, and I will turn it over to you.
Well, thank you very, very much. It is a pleasure and an honor to be back working with Western Center. So many terrific things you have done, and I've been delighted to get the chance to engage at times. So last time, the division that Corey and I talked about was last time we would do the basics, and this time we would do the crazy stuff. And didn't quite get through all the basics last time, did not get access to judicial review. So I will talk about that just briefly, and then I will switch over to the crazy stuff, otherwise known as today's headlines. So, I'm trusting that my slides are now out there. Access to judicial review. The basic preface to having judicial review is that there needs to be law to apply. That's in Section 701A of the Administrative Procedure Act, that judicial review is generally allowed unless statutes preclude it, or unless agency action is committed to agency discretion by law. And the Supreme Court, in a whole series of cases, has held that there's almost always law to apply, and it has generally interpreted restrictions on practice very, very narrowly. Probably the best known example of that would be the restrictions on judicial review of Social Security cases, and where there are not individual disputes, but challenges about whole broad practices, the court, in a series of cases, most of which are fairly lousy on the substance, said that someone who has applied and requested reconsideration has done all the exhausting they need to get into court. So we've got pretty good law on the law to apply, not committed to agency discretion area, although that is certainly something the current administration has shown a lot of energy in trying to revitalize. We'll see how far that goes. I would guess that it would be easier for them to revive committed to agency discretion if they would show any discretion. but that's maybe just me. The timing of review can be an issue. Agencies' actions are made reviewable when there's no adequate remedy. Preliminary, partial, and intermediate decisions are not reviewable. Most of the law on that basically says you can't get review over what you're afraid is going to happen. And the administration currently is trying to say all sorts of things that have had very real effects on real individuals are unreviewable because they aren't finished. The law is very clear that once you start doing things to people, as opposed to considering doing things to people, that there is finality, at least to the extent that you're doing things to people. So that's probably going to get litigated, but I think the law's pretty good for us there as well. Timing, ripeness is one doctrine, which requires two things. The clarity and finality of the action is sufficient to allow judicial review, and you have to consider the harm the challenging party would suffer if forced to await further action. Again, this is an act now, think later, if ever, administration, from what we've been seeing. So I think that the harm factor will weigh very much in our favor. And to the extent there isn't clarity, the case law on lack of clarity is where the administration is still thinking about what it wants to do to people. Here, there's often a lot of clarity because they put out multiple directives to do more or less the same thing. And that lack of clarity is their part, and it would be weird indeed, otherwise known as a stopped, if they were able to claim lack of reviewability because their justifications for their actions are word soup. Lack of exhaustion is not generally required under the APA. It is under some particular statutes. This administration is also, surprise, surprise, getting very interested in exhaustion, although they're doing this at the same time they're getting rid of the channels that one might use to exhaust. So the law here, again, is pretty good, and the behavior of the current administration does not suggest a lot of equities for changing it. The general right of review under Section 702 is quite broad. Adversely affected or aggrieved by agency action, and actions defined by the substantive statutes, which again, the statutes that almost everybody in legal services community works on are relatively clear about what people are supposed to be getting. Standing is the biggest issue, I think, that we've historically faced, and I don't think that's going to change anytime soon. The leading case all these years later is still Lujan versus Defenders of Wildlife, which says that you need harm that is concrete and particularized. It needs to be actual or imminent. And it needs to be fairly traceable to the challenged action, and it must be redressable by a favorable decision. The administration is putting a lot of weight on standing and hoping to go a long way with standing. The actual or imminent, that's going to make challenges to many of the executive orders difficult. More on that in a moment, because a lot of them say, oh, do this to the extent that it seems useful and only to the extent that it's legal. And some of the courts that we've been ruling on what the administration has been doing have been going off under actual and imminent and saying that the stuff that the administration has committed itself to may not be actually or imminently harmful, and that the courts will not assume the worst from generalized statements in executive orders. So we are likely going to have to show things that are more imminent than just a broad executive order, the way most of them are written. A few of them are not written broadly, or a few of them are absolutely actual or imminent themselves. Similarly with the problem with the concrete and particularized, They have often been saying in their defense to the litigation, oh, you have no reason to believe that we're coming after you, even though you fit the criteria that people were coming after. So that's been a challenge as well. I think, again, looking at things below the executive order will be helpful for that. Fairly traceable, sort of bound up in the same thing. And then, surprise, surprise, they're making a big effort on redressability. Most obviously in the case of the people that they've been sending to El Salvador, saying, well, this case should be dismissed because we already did the thing and it may have been a mistake, but we don't control the El Salvadoran prisons, although we do fund them. The case should be dismissed. So far, that hasn't been going well for them. But I think we absolutely need to be super clear about what redress we think a court, what remedy we think a court can give us, and how that will redress injuries that they are undertaking. Most of the time, that's going to be fairly clear to state in our cases, but every now and then, particularly when they're messing with procedure, that may be something that needs to be brought out some. Savings clauses, I mentioned, are a big part of most of the executive orders, not all of them, but a whole bunch of them. They say, do this consistent with law to the maximum extent the law applies, blah, 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 blah. And there's great Ninth Circuit law in a case against a guy named Trump. Not sure who that is, from 2018, says that you have to read savings clause in context, and you cannot command someone to do something illegal and then say, but only to the extent of the law, and have us take it seriously. The specific governs the general. If there's a specific command to do something that is unlawful, you can't make that unreviewable by simply saying that it's only to be done consistent with law. I guess you could say that also affects the rule against surplusage, that the whole executive order would be a waste of time if they didn't intend you to do these unlawful things. So there must be some meaning to it, and if that meaning is not legal, then the courts have capacity to hear it. Other elements of standing, the plaintiff needs to be with the zone of interest in the statute in question. On some funding challenges to cutting off funding that have been brought by federal employees, they've said you're not the people we're trying to protect. Again, for legal services cases, zone of interest isn't usually much of a worry. And no preclusion of review. They have certainly been trying very hard to imagine ways in which review is precluded on that. So, and back on standing, it's always worth remembering that there are two kinds of non-individualized standing. There is the kind that says what you are doing is costing our organization resources. The standard example of that would be a food bank that's getting too many demands because SNAP's been cut. Or in the actual case of Havens Realty versus Coleman, a housing counseling agency that's having to do a lot more work because of all the racial discrimination in the housing market. And if the owners wouldn't discriminate, the agency would have much less work to do. That is separate from group standing or aggregate standing. The early case, and it hasn't really been disturbed that much, is Hunt versus Washington State Apple Advertising Commission, and that has three elements. One member of the group would have standing to sue individually. The nature of the injury is germane to the purposes of the group, and the case does not require the participation of individual members. Given how much intimidation is going on and how ugly the administration is being, certainly filing cases pseudonymously may be appropriate in some instances, but also group standing may be useful because it doesn't, there isn't even a secret individual who is brought forward, and one needs to worry less about a crummy judge ordering someone to out themselves. So that's what I wanted to say, covering the basics on access to judicial review. Mootness interacts with standing in the sense that a case is moot if the plaintiff had standing when the case is filed but no longer does. If the plaintiff had standing but lost it before filing, that's a standing problem. And there certainly are a number of those, particularly in the police violence area, cases that are problematic there. Not usually a problem for our clients, but worth keeping in mind. There are exceptions to mootness for harm that is capable of repetition yet evading review. And the evading review prong of that, I think one can make very strong arguments that because this administration is acting so secretively and is disregarding laws that it regards as invalid without giving anybody warning of that, that lots and lots of stuff is almost structurally evading review. Voluntary cessation of challenged actions does not create mootness if the agency could resume it. That's certainly true for this administration, which has stopped and started funding freezes and staff purges on a number of occasions. Class actions are not mooted out if the named plaintiff had standing when they filed and other class members have non-moot claims. So on to executive orders. Starting point, I've sort of hinted at this before, statutes are really important, executive orders really are not. There are a few powers the president actually has that get exercised through executive orders, a lot of that in the national security area. A few in the immigration area, hardly any in the public benefits or housing areas. But in the absence of some presidential power, an executive order doesn't do anything. And if you read them closely, they mostly don't do anything. They mostly say, to my staff, please do something. So they're really no different than something he says while sitting in his golf cart on his golf course. They're just out there published. So I think we need to see executive orders for what they are, which is in most instances the starting gun on a race to undermine our clients or somebody else's rights, rather than something effectual itself. When they put out an executive order on something, that tells us they're planning on going after that activity or that agency or those people, but it doesn't tell us, it itself does not tell us what's going to happen. The problem typically comes later. You might compare this to lions. If you know anything about lions, the guy on the left there, he's doing nothing. He's sitting there and looking regal, but he's too important to bother hunting or anything like that. The problem is on the right. Those two mean business. Those two will absolutely take you down. So it's the implementing memos, it's the phone calls from the nameless people at the White House Personnel Office or from OMB or whatever. That's where the harm comes. And we should note that even if an executive order could be implemented in a thoughtful, careful, and legal way, the people who would do that, oh, they're not employed anymore. We can certainly assume for our own purposes that these executive orders are likely to be read in an irresponsible way. There's certainly plenty of history and evidence of that. I don't know how far along courts are in being willing to drop the traditional presumption of governmental regularity, the presumption the federal government tries to follow the law. It is clearly not even very interested in what the law says, much less following it at this point. I think a lot of judges don't want to say that out loud. I'm guessing that they are more aware of it. But certainly the quality and accuracy of implementation of these things is going way downhill, and we should be attacking that where it affects our clients' well-being. I now want to talk about impoundments. My guess, which could easily be wrong, is that those will not be a big deal for the entitlement programs we work on, like Medicaid and SNAP, but that they could absolutely be important for programs funded with appropriations, such as child care, housing programs, LAAC, and WIC, among others. I'm gonna, which are all important programs, so I think it is worth my while to talk a little bit about impoundments. A lot of this is pretty mangled in media accounts, and indeed, I found that a lot of people on committees that ought to know better in Congress are pretty confused about this stuff as well. To understand impoundments, you really need to understand how federal money is spent. It's a four-part process. You start with an Appropriations Act from Congress that provides budget authority. That money then goes to the Office of Management and Budget, next door to the White House, and they are required to apportion it. There's actually a statute that says the appropriated money cannot be spent until it is apportioned by OMB. The point of apportionment originally was to keep agencies from spending it all in a month or two and then coming back to Congress for more. So the apportionment would typically say you can have 1/12 of this each month so that you don't run out and you don't come back to Congress. What OMB has done in practice is use the apportionment as a way of bossing agencies around, sometimes in constructive ways about transparency and accountability and all that good stuff, and sometimes in very destructive ways. When President Trump wanted to stop money from going to the Ukrainian government until they would investigate the Bidens, what he did was have OMB apportion the money in ways that did not allow them to be spent. You can, I'm not remembering exactly what they did, but so, you can spend this money on the 32nd day of any month, that sort of thing. After it is apportioned by OMB to an agency, in most of the case of programs we work on, everyone knows which agency is getting it, but they still have to apportion it by law. The agency then obligates the money, which makes the federal government legally obligated to pay somebody outside the federal government. And then the last step is they actually do pay somebody outside the federal government. So to take SSI, the Appropriations Act turns out to be the Social Security Act. It's not funded through annual appropriations, but through the Social Security Act, provides for the money to go out the door. OMB apportions it to SSA. It may, in a portion, require various program integrity measures. Traditionally, when an individual applies for benefits and proves their eligibility, then the money becomes obligated to them, and every month we send them a check. Fairly simple. For WIC, it is funded through the Agricultural Appropriations Bill annually. The apportionment likely limits spending to about 1/12 of the money appropriated money every month. The money becomes obligated when it becomes too late to legally cut off a recipient's benefits. The deadline to terminate them passes, and then we outlay the money by paying the grocery store for the food that it gave to the WIC recipient in exchange for the voucher. If a president wants to restrict funding, they can obviously act at any of these stages. They can veto an Appropriations Act and we have a partial government shutdown. Fine. They can order OMB not to apportion funds. They can order the agency not to obligate the funds, or they can order the agency not to pay the funds out the door. This administration has not vetoed anything, the one thing they clearly legally can do, but they have messed around with all the rest of these through their assorted memos. And usually they don't have the legal right to do that, and I want to talk through why. You need to start by understanding that statutes, funding statutes, fall into three categories. There's mandatory programs, which are programs where the permanent law is all that is needed. The legislature, Congress is not holding back any discretion for itself, and it's not giving the president any discretion. It's just saying, get this money out the door. So aid shall be paid promptly to all eligible individuals who make application is standard mandatory language. And if there was some of these programs get appropriations, some don't, but it doesn't matter because someone could go and sue in the Court of Federal Claims if they weren't paid, and this language would give them a winning claim, and they would then be paid out of the judgment fund, which has a permanent uncapped appropriation. Second category is discretionary programs, but the only discretion is in the appropriation amount. WIC and Section 8 would be examples of this. This is something where, or LAAC, something where we say we're not providing any money up front to be spent. That'll be handled in annual appropriations bills. But once the appropriations bill provides the money, that's it. There's no power reserved to the president. So each state, funding formulas are often the way this gets mandated. Each state shall receive its share of the appropriated funds that bears the same ratio to whatever the formula is. The shall there forces the money to go out. The only constraint on the money is how much is appropriated. And then there's a final kind that we don't have a lot of in our world, where both future congressional and future presidential discretion is allowed for in the permanent law. A good example of this is the Stafford Act on disaster relief. The president, if he doesn't want the money to go out the door, can refuse to declare a disaster, and then the Stafford Act doesn't apply, and that's completely legal because Congress said that's something the president can do. We need to look at both our permanent authorizing statutes and, for those that are non-entitlements, at the annual appropriations to see in which category our programs fall. They're mostly in the first two. I can't think of one, or at least a remotely significant one, that we work on that falls in that third category. So, for example, here's the SSI entitlement. Everyone shall, in accordance with this, be paid benefits by the commissioner. The end. No discretion whatsoever there. In LAAC, it's not a mandatory program. It is subject to appropriations, but once the appropriation gets out there, this statute says that the secretary shall allot to each state its amount set out in the funding formula. So again, no way to sue if they didn't appropriate money, but once they do appropriate money, then it becomes mandatory from there on out, and the secretary has no discretion. Secretary shall, not may. This is just something I was working with separately. It's not one of our programs, of course. But it was a good example. This is an appropriation for a USAID program called Development Assistance. And why I found this interesting is it provides this money, and then in the proviso, it says, and this shall be apportioned to USAID. So Congress, because it's been burned by bad behavior by the first Trump administration, here has expressly required the money to go out the door, compelling an apportionment. That's unusual. You don't see that in a lot of them. They only do that when an administration has misbehaved previously. But you can read this appropriation, and there's no way that anyone has the discretion to hold back this money. So that is also money that has to be spent. And there are other things that can be wrong with impoundments, with holding back money besides violating authorizing and appropriation statutes. This is language from the terms and conditions of the National Clean Investment Fund, part of the Greenhouse Gas Reduction Fund, that the administration canceled. And as you will notice here, there is no authority to cancel. That just, and I mean, obviously it's 200 pages of terms and conditions, but nowhere in any of them is anything better than this. And the most that EPA could do if it found non-compliance was add additional conditions. And they haven't even found non-compliance. They've just said, we think this is a really bad idea. Well, good for you. No one asked. We should also look for situations where contracts, be it with housing agencies or WIC agencies or whatever, may require some money to go out the door that could be beneficial to our clients. And finally, mass firings can also be impoundments. Again, this isn't one of our programs, but as you see here, this agency, which the administration has decided to get rid of, has an appropriation. It now has an appropriation signed by Donald J. Trump Sr. And here Congress provided this money should go out the door. So many appropriations acts, which I never lived in appropriations act when I was in a field program, but it's something that if the administration starts coming for our programs, we should absolutely look at these things. I should also say that a mass firing can be an impoundment in a different way, in that if it stops programmatic money from going out the door. I was told yesterday that literally everybody at HHS who works on LAAC was fired a couple days ago, including the person who runs the funding formula. And that they have not yet sent out the balance of this year's money under the full year appropriations bill, and there's nobody there to do it. So if they bring in somebody from the central financial office of HHS and they send the money out to the states, I guess that's fine. But if their mass firing of LAAC staff means that the states aren't going to get their share of LAAC money, then that is quite illegal. This brings us to the Impoundment Control Act, but it's a dicey little thing. So I want to talk about it a little bit. I'm not sure it's worth talking about more than a little bit. It gets mentioned a lot in media accounts, but I actually think the authorizing and appropriation statutes are really what we want to look at and what we want to sue under if they mess with programs that our clients need. The Impoundment Control Act says that nothing in it supersedes other provisions of law that require obligating budget authority or making outlays. Well, our clients have all kinds of provisions of law that require obligation of budget authority or outlays. There are rumors the administration is thinking of following the Impoundment Control Act and seeking rescissions of funds, but nothing in the act or anything made under the act can supersede, for example, provisions of the Medicaid statute or the Food Nutrition Act. The Impoundment Control Act covers acts and omissions. It covers things that effectively preclude spending as well as formal orders to not spend. And it covers both obligations of money and expenditures. You can't interfere with any of this stuff. If you can't interfere with an obligation, then you can't fail to apportion. There are two options the administration has. It can ask Congress to rescind money, or it can defer money. Rescissions are saying we don't think the money can be spent. They can use any rationale they want, but they can't implement it unless they can get Congress to pass a rescission bill. within 45 days. Deferrals, that's waiting till later in a fiscal year to spend money, shouldn't be very pertinent now because we're already getting fairly late in the federal fiscal year. But these are not allowed for policy reasons. They're only allowed to maintain a contingency fund or if spending patterns are disrupted by technology in some way. So I don't think this administration has any interest in deferrals. They're bragging about rescissions, but they're not complying with the act. They're not getting the congressional authorization, which makes this illegal. If they fail to get congressional approval for a rescission, then the money shall be made available for obligation right away. The ICA is not, I think, a good cause of action for us to sue under. I would urge suing under the Authorizing or Appropriations Act for whatever program they're messing with. But I still think it's relevant to get injunctions. And 3 of the 4 factors in the preliminary injunction test seem to me to touch on the ICA very much. The ICA recognizes, Congress recognizing that withholding money can be irreparable injury. There's some ancient English law that raises questions about whether a lack of money can be irreparable injury. That's pretty stupid in its own right, and I think not followed by many courts. But if they try to dredge that stuff up, Congress has clearly indicated that impoundments are a big deal by passing the ICA. Even more directly, at the balance of equities stage, there's tons of law that says that you can never appeal to equity when you're violating a law. If they're violating the ICA, even if we are not suing them over specifically with an ICA cause of action, it's still the ICA, and their violation of the ICA means that the balance of equities can't favor them, and complying with the law is in the public interest. So I would encourage us to sue on our appropriations and authorization laws, but to mention their violations of the ICA so that we can use that to get preliminary injunctions. Lots of law. I ran out of room on my slide, as you can probably tell here, that is very, 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 very good on this. President Nixon impounded lots of money for all sorts of programs, highway programs, housing programs, nutrition programs, you name it, environmental programs. He lost every single case that was decided on the merits. A few of them went off on standing, but where it was decided on the merits, he lost every single one of them, including 9-0 in the Supreme Court in Train versus City of New York, where they interpreted the appropriation and authorization language in Clean Water Act as saying the money needed to go out the door. That language is not very different than that in the laws affecting funding the programs that our clients care about. Rehnquist signed the majority opinion without separate comment. It was not controversial. City of New Haven versus US. For complicated reasons, the ICA, the Impoundment Control Act, was temporarily not applicable, not available. It needed to get amended, and it subsequently did. But during a period when the Impoundment Control Act was not effective, President Reagan found 4 HUD programs he didn't like and said, we're not going to spend the money on that. He got sued, and the court said, if you don't have the ICA, you can't defer spending at all for policy reasons. So the money has to go out the door. So the ICA is not essential to make presidents spend money. The current administration says it's unconstitutional. They're wrong, but I don't really care because the ICA is not their problem. Some irony is that the City of New Haven case, one of the judges on the panel was Robert Bork, who had argued the impoundment cases for Nixon, including Train versus City of New York, and he opened the oral argument with a question of the government's lawyer. I wasn't able to make impoundment stick. What makes you think you can? Well, nothing. He was not able to. So if you can't get Robert Bork for impoundments, you really can't do much of anything. And in Clinton versus New York, Congress authorized a form of impoundment, and the court still said 6-3, that's not okay. Rehnquist and Thomas were in the majority there, neither writing separately. So it's pretty clear as a matter of budget law that this is not okay. There have actually been 2 or 3 very technical budget cases decided in the last 3 or 4 years by the Supreme Court, all with lopsided majorities, all coming out in very good places. It's too technical to be worth doing here, but if you get in on one of these, you will have some happy surprises. One of them authored by Neil Gorsuch and another authored by Clarence Thomas. Moving on to the war on civil rights. I was brought up that we were supposed to be cheering for the guy in the middle, but these people seem to be cheering for the 2 on the sides. But if you look more closely, a lot of this has been a great big bluff. The executive order bans only illegal DEI and discriminatory programs. I can't imagine anyone on this call supports discriminatory programs. I can't imagine anyone on this call wants any illegal DEI. I prefer the legal kind. So the only prohibitions here are for the illegal stuff. They're going to have to adjudicate what that is. Of course, the underlings aren't reading it that way. They are treating any hint of DEI as being problematic to the point where they were troubled by the Smithsonian's exhibition of the Enola Gay. That's what I mean by the problem is with the underlings much more than the executive orders, and we're going to need to build cases against what the underlings are actually doing much more than on the text of the executive orders, with a few exceptions. And by the way, they're not defining diversity, equity, and inclusion. They just are against illegal versions. Well, I'm against illegal anything, so that's fine. And what exactly do they mean? Diversity is what separates a beautiful impressionist painting from some charcoal smudges. Equity is a form of jurisprudence that goes back to St. Thomas of Becket. And if we didn't include people in the armed forces, we would be defenseless. So which of these words is so bad? Help me here, please. But in all seriousness, their lack of a definition, I think, puts them in a very vulnerable position. We should remember that in lots and lots of settings, DEI is statutorily mandated. Head Start has to do special things for kids with disabilities. It has to do special things for people who are members of Indian tribes. SNAP has to do special things for the elderly and disabled people, people living on reservations, people living in areas where substantial numbers of people speak a language other than English, and has to monitor changes that disproportionately affect any of those people. The litigation about this has so far been mixed. I think this it has been misunderstood and misreported by the newspapers. The National Association of Diversity Officers in Higher Education case in the Fourth Circuit lost, or they got the preliminary injunctions stayed because the courts looked at the executive order and says, well, it's only against illegal DEI, and who can object to banning illegal DEI? So it really doesn't do you any harm. And we are not prepared to assume that they're going to do something illegal. I am, but they aren't. This isn't really of any matter if you're challenging some specific action that they are shutting down or prohibiting or eliminating in some way, and you get some validation from that in the First Circuit's DEI case, where they actually were challenging some real activity, some real movement on the ground, and they said that the administration was ignoring Fox Television, a case authored by one and Scalia, in not addressing the requirement to show good reasons for the new policy and account for serious reliance interests in the old one. So where we have something concrete on DEI or on most of this other stuff, I think we should feel free to go ahead, but we should challenge the actions more than just the EOs on their face. The order on English as an official language of the US, extremely obnoxious, but also extremely empty. It goes right out and says nothing in the order requires or directs any changes. So we're just running our mouths here. And it'd be so lovely if you wouldn't, but it doesn't have any impact on our clients. Here again, a lot of service for non-English proficient people is not just allowed but required by statute. Here it is in Head Start, and here it is in SNAP. Moving along, the war on immigrants, obviously a very complicated topic, but I just wanted to pick up one particularly bizarre aspect of this, illustrative of something much more, which is the Alien Enemies Act, where they scooped up a bunch of people who they said were Venezuelan, seems like most of them were, and said were gang members, seems like many of them were not, and put them on an airplane and put them in a hellish prison in El Salvador. And this applies, this was enacted by John Adams. It's part of why we got a President Jefferson, because people thought John Adams was so awful for doing this. But it's still with us, and it applies only in a declared war or an invasion by a foreign nation or government. It is at best bad poetry to claim that immigrants from south of the Rio Grande are an invasion, and to show that they are the result of Maduro decisions or actions is simply preposterous. This would, the notion that it's been used 3 times in the War of 1812, the First World War and the Second World War, which all were declared wars, and to say that people fleeing the collapse in Venezuela that we have been engineering are the equivalent of the Redcoats, the Germans, and the Germans is pretty ridiculous, and is a great example of where the major questions doctrine applies. Congress does not hide an elephant in a mouse hole, the court has told us in these cases, some of these preposterous interpretations of statutes, whatever we think of the major questions doctrine as had been used previously, is certainly ripe for attack on these grounds. I would also mention you that Chevron is no longer, and so none of these fine people are entitled to any Chevron deference. Agency closures, again, not really something that we work on very much, but just because it's happening and because so many of the agencies that administer the programs we work on are affected, I wanted to make a quick gesture to it. Lots and lots of the agencies they're shutting down are statutorily mandated. The agencies that running our programs are a mix. Some are mandated by statute, some are referred to in statutes, but not explicitly set up the way education and AID are in the 2 statutes I give you here, and some of them really are creations of the secretary and could be done. What the president has been doing is putting out executive orders saying that we will continue their statutory functions, but not their non-statutory functions. The work stays, the fun goes. Well, if that was really what it meant, not great, but one could live with it. But they've got these people coming up with the definition of what is or is not a statutory function. They have, for example, for the Inter-American Foundation, they said, well, the statute says you need a board, you need a president, you need an office, and that's all you get. All the stuff in the statute about functions is completely optional. There's nothing in the statute to support that. So to the extent that they're doing that apparently now to the people that run LAAC, and I suspect other people, I mean, apparently a lot of folks in HUD, and sooner or later in the other programs that we care about, there certainly may be grounds to argue they're violating the statute by thinning out the staffing there. You could say, well, is that really our client's first concern? Not saying we should be bringing litigation solely because of that, but I think it may be something worth mentioning where there are consistent screw ups, and certainly something that should be in the equities in our briefs for preliminary relief, because they've stripped down the agency so much that if a court later finds they messed up, there may not be anybody there to fix the problem. Intimidation campaigns, of which there have been a lot for anyone who hasn't been mean to a LGBTQ plus person, to anyone who makes any reference to DEI and all sorts of other things. Again, a very comprehensive topic, but I just want to note that the attack on sanctuary jurisdictions has got all that limitation to lawful actions in it. And it only goes after entities that interfere with the law. Well, most sanctuary jurisdictions that I know, they're not interfering with anything. They're just not helping. And they're not interfering with the law so much as they're helping the people and not the feds. So there's a good argument that on its own terms, it doesn't affect things. Obviously, that's not how the underlings are implementing it, but I think it is worth in litigating these sorts of things, should it be necessary, under whatever executive order, to point out that the president, not that the president has the authority to violate law, but the president specifically didn't tell them to, and that may make it easier for a court to issue an order that slaps down lower officials rather than the EO and the president himself. Lots of statutes limit federal authority to meddle. We usually like meddling feds, but not now. So it's worth keeping these in mind. Here's a limitation from Head Start. They don't get to control the curriculum or meddle in the curriculum. In SNAP, they don't get to meddle in state forms, materials, documents, memoranda, bulletins, and other stuff. And in SNAP, of course, in TANF, they can't regulate anything unless there's a clear statutory authorization to do that. There's a lot of law that most of the time we just hate in this area, and just want to mention it briefly. Anything where they're picking on one of our states because they are nice to immigrants or they do some DEI or whatever, is arguably denying states equal sovereignty, which there's a ton of con law, most of it in cases we hate, that's pretty good on that, and in this setting may be useful. All the states enjoy equal sovereignty. They're equal in power, dignity, and authority. They can't have their powers diminished, impaired, or shorn away. You can't diminish their perfect equality. And Congress cannot use the spending clause to secure state compliance with federal objectives. Certainly not in a setting where it is a gun to the head and where there's economic dragooning, giving states no real option but to acquiesce. I think there's some of that going on. And worth remembering the famous, and deservedly so, comments of Justice Jackson in the Steel Seizure case that the president's power is at its lowest ebb when it is clashing with what Congress is doing, and must be scrutinized with caution, because allowing presidents to do that is limiting the powers of Congress, which is not something courts should casually do. And sanctuary cities are creatures of the state, and the state is supreme, and the Supreme Court has said that we should understand cities as creatures of the state. So many of those rights of states extend properly to our cities. And then finally, I'm running out of time, but also out of slides, which is the way it's supposed to be. Just a few comments on contempt of court, of which there is an awful lot out there. They've been responding in various ways to court order, what I call three-order Monty. They keep doing what they're doing and say they've come up with a new legal authority to do it. That's been happening in several cases. Sometimes they take a crazy broad reading of any exceptions in the court order that allow ordinary conductive business. So, for example, the court said they can enforce contracts in the ordinary way, and they say, yeah, we're enforcing them by canceling thousands of them. And if a court denies them that kind of exception to keep it from being abused, then they complain the court's not letting them do the business of government, as if they had any interest in doing the business of government. They're also wrecking their capacity to comply with the law and using that as an excuse for non-compliance. This seems like a very good argument for preliminary relief, that everything is irreparable if they've made it impossible to fix their errors. Whether by not having enough staff to turn funding back on or sending people to El Salvador. And then sometimes they just ignore them. So I would just remind you that there are two kinds of contempt of court. Criminal contempt is a crime. It's also subject to the pardon power, but civil contempt seeks to coerce compliance. It is not subject to the pardon power. Courts using civil contempt orders cannot be interfered with by the president. And I don't have a lot of time for questions. I apologize, but happy to take any that there are available.
Thank you so much for such an incredible wealth of information. We have time for maybe one question. If anyone has a question, please feel free to come off mute. While we wait for that, I just want to thank you, Professor Super, and see if there is anything on the horizon that particularly worries you, that the administration hasn't done yet, but could be doing in the near future. I'm sure there are many, but what worries you the most?
I mean, what worries me the most is the reconciliation bill. The level of cuts they're contemplating to both SNAP and Medicaid and student loans would be transformational. These wouldn't be the programs that we've had for many decades if that happened. And I think it is not clear where they stand on this. They are having some problems with their own ranks, mostly in the Senate, not so much in the House. But at present, we are seen to be on course for them moving pretty rapidly on some pretty devastating legislation. I would also say that in the program, most of the programs we work on, they don't have people in office yet. They've got appointees that are waiting confirmation and lower level people that are not in there yet. So I don't think we know yet what they will be doing by way of regulatory initiatives. But my suspicion is it will be pretty aggressive because everything else has been.
Well, both of those are very bleak options for us, but hopefully you have inspired lots of fight and armed us with lots of information to fight back on behalf of our communities and our clients. I want to thank everybody for joining us today. I will send out a link to the recording and a copy of the slides, as well as a link to our survey for MCLE credit. And with that, I will thank you again, Professor Super, and wish you all a great day.
Thanks,
Thanks.
David.